If you kind of just tell me what this is, and I'm just going to flip through the pages. I've got motion for leave of court. What is that?
Right. So, in the last visitation order that was entered in the juvenile court, and I don't have it in front of me right now, but I think it was in September of 2019 or thereabouts.
Do I need to call you back then?
Maybe that's.
Do I need to call you back when you get to the office, or?
No. It doesn't really matter when the order was entered, but the substance of the order is that Ramon is not permitted to file further motions in the juvenile court unless he's been granted leave of court. And that's just in the visitation order. That was one of the things that just kind of surprised me about the litigation history of this case, because that's a very unusual step for a court to take, to say, oh, well, you can't even come back and ask us for other changes or anything else until we've had a chance to look at your filing first and decide that it's not, or that you should be permitted to file it, I suppose.
Oh.
And I can send you a copy of that visitation order later today. I know I've certainly got it.
Okay.
I should actually have it scanned already. And also I am going to be attaching it to at least the verified petition when we get to that. And so before we even do anything as far as enforcement or, even really further modification. Now, this does not affect the current appeal. This is just for new actions.
Okay.
And so for the custody visitation order for the visitation order that's currently in place, before I can go forward with the enforcement, all I need to do is just kind of provide the court advance notice that, look, this is what we're filing, this is what's going on, and we believe that this is a motion or an action that is grounded in facts. We believe this is a real matter of controversy. We believe this is a substantive violation. This is not a frivolous matter. This is not a matter that we're putting on to harass Miss Harris or anything like that. We're not doing this for any proper purpose, but we need to bring to the court's attention that she is violating the order. We need some relief. This is what we want to get some relief. Can we please move forward with filing? And because of the way that visitation orders, or I guess really any visitation action, is set up in the juvenile court, we have two copies of that motion because each child has their own case.
Okay.
And so there's a case number for Ramon Jr., and then there's another case number for Rain.
Right.
And so even though we only need to file one enforcement matter, and I can get to that in a minute, but that's the reason I have two motions for leave of filing. And I'm sure that you've seen that they're substantially similar. The only difference between them is that one has the information for one child and then one has the information for the other.
Right.
And so that's just so that I don't file only for one. And the court says, well, you only asked for leave of court to file for one child, so you only get to ask for enforcement of the visitation order as to one child. So I don't want to get stuck into that kind of just
technicality, really.
Yeah. I guess procedural error, we'll call that. And so that's why we've got two copies of that motion. And that's the only goal of that motion, is to make sure that we're going about this in the correct way.
Okay.
And you'll see this when I send you a copy of the current visitation order. And the visitation order, where it says that Ramon has to ask for leave of court to file, it does not specifically say that he needs leave of court to ask for enforcement. However, I think it's a wise idea to file the motion all the same, because I don't know if the court also intended that enforcement actions be included and it just wasn't specifically listed. And so I'd rather file that with the court and have the court say, we appreciate this, but you didn't actually have to do this, than to not request leave of court first and then not be able to get any further relief because they say, well, you were supposed to ask for leave of court and you didn't. So I just want to make sure that we don't get the door closed prematurely.
Absolutely. Okay, so I've got understanding. Now, what about this next one? The verified petition and rule to show cause.
Right, and so that is a pleading that permits the court to enforce an order, and I think that Ramon has done a few of these in the past on his own accord. I know that the juvenile courts do have a form that they use sometimes. However, they do also accept these longer written pleadings, and I also prefer to do these longer written pleadings because I think that they better describe the conduct for which we're seeking enforcement. And of course, as we'd discussed earlier, he's got these certain visitation rights to him that were provided by the court. He's supposed to have time with the children. I think it's once every 2 weeks. And then he's supposed to have telephone contact with them every week. And of course, with the current circumstances, I'm not really pushing the visitation aspect. I mean, one because I don't necessarily know that the court would say, okay, the kids have to go see him in the Loudon Adult Detention Center, and
right.
Then also, we've got the problem where I don't really think that they're allowing in-person visits anyway.
No.
Just, until some unknown date in the future. And so I'm not asking for enforcement of a provision that is not really realistic for us to be seeking enforcement of anyway. Mm-hmm. However, and so that is only going toward the issue of the phone calls. And he's entitled to speak with them once a week, and the visitation order outlines how the call is supposed to happen. And of course, the problem is that, the way that the phone call is supposed to happen is also not really anything that is realistic at this time. But that's why we had the letter correspondence where he said, look, we've got this provision, or letter correspondence with Sabrina saying, look, we've got this provision in the order that he's supposed to have these phone calls. We can't really do the letter of the order now, but, we would still, he's still entitled to this kind of contact with the kids. Here are some ways that we can make this happen.
Right.
And we're going to attach a copy of the letter as well. It's going to outline, these are the possibilities. We can have this call just be on the same day but later, when he would have the opportunity to speak with them, and one wouldn't interfere with their school or any kind of after school activities they're doing. Or, can we just have it be on a Saturday instead of on a Tuesday?
Okay.
And here is a possible time for Saturday telephone contact. But, also let us know. Like, these are the things that we're proposing, but we don't know you. We don't know your life. We don't know the children's schedule right now. And so, if these are unrealistic, then please send me your realistic for you and realistic for the children proposal. And whatever it is, we're going to try to make it work because he wants to talk to his kids.
Absolutely.
He's got the he should have the ability to talk to his kids, and he's got this court order that says this man gets to talk to his kids every week. And it's one thing to say, oh well, he was in the detention center, and so he couldn't call them on Tuesdays, or I couldn't call him on Tuesdays at 4:30, and so I just couldn't do it while he's there, and it's not a willful violation. It's just I didn't know what to do. But now, that we are providing